Welcome to this explainer. Look, we all know legal research can feel pretty intimidating, right? But today, we're totally transforming it into a methodical, step-by-step detective process. We're going to break down the exact framework that forms the absolute backbone of all legal problem solving. Because honestly, whether you're a law student grinding through assignments or a seasoned practitioner, mastering this toolkit is literally what separates a decent argument from an unshakable one. And frankly, it's what separates a multi-million-dollar win from a devastating loss. But before we get too deep into the weeds, I want you to think about what legal research actually means to you right now. Have you ever hit a brick wall trying to apply these skills during an internship? Or maybe you felt completely overwhelmed, drowning in a sea of statutes, desperately trying to find that one perfect case precedent? Keep those specific frustrations in mind, because today, we're going to systematically solve them together.
Here is our quick game plan for today's investigation. We'll start by defining legal research, look at our investigative methods, step into the evidence room, learn how to decode clues, and finally, outline the exact methodology.
All right, let's jump right into Section 1, defining legal research, or as I like to call it, the brief.
So legal research, it encompasses way more than just frantically plugging keywords into a database and hoping for the best. It's a highly active process. You're identifying and retrieving the exact information necessary to support legal decision-making. It requires systematic analysis of principles, strict interpretation of some incredibly dense statutes, and most importantly, applying those high-level theoretical concepts to messy, real-world client facts. Basically, it's the crucial bridge between the law as it's written and the law as it's actually applied.
And this is exactly why research is the absolute backbone of the entire legal profession. It scales across every single stage of your career. In academia, it's make or break for moot court. During clerkships or internships, your research skills directly dictate the quality of your drafting. And out there in actual practice, it is the absolute foundation for litigation strategy, public interest advocacy, and massive corporate transactions. Every single legal solution, no matter how complex, starts with effective methodology. Moving right along to Section 2, investigative methods, specifically doctrinal versus non-doctrinal. You can visualize the research process as two very different but highly complementary vibes. On one hand, you have that quiet, traditional analysis, surrounded by heavy books and bound journals. But contrast that sharply with real-world, on-the-ground investigation, where researchers are out there actively engaging with people and raw data. The crucial distinction here is doctrinal versus non-doctrinal research. Doctrinal is your classic library-based inquiry. It focuses purely on the black-letter law, strictly analyzing statutes and precedents to figure out exactly what the law actually is. It's very theoretical. Non-doctrinal research, on the other hand, is empirical. It steps outside the library to see how the law operates out in society, bringing in real-life data like interviews, surveys, and statistical analysis. To see how these two methods beautifully merge in the real world, just think about a public interest litigation against environmental pollution. You'd obviously start with the doctrinal stuff, constitutional provisions, the Environmental Protection Act, Supreme Court precedents. But to build a truly airtight case, you have to integrate non-doctrinal clues. We're talking actual pollution measurements from the affected area, health impact surveys from the locals, expert scientific testimony. That integrated holistic approach is how you win. Okay, Section 3. Welcome to the evidence room, where we categorize our sources of law. Just like a master detective has to tell the difference between a smoking gun and just circumstantial context, a lawyer absolutely has to establish the hierarchy of their research materials. You cannot treat all information equally. You need to know exactly which sources hold the ultimate authority. First up, the highest level of evidence, your primary sources. These are your undisputed heavyweight champions. We're talking the Constitution, the supreme law of the land, along with original statutory bare acts, judicial case law that sets precedent, and administrative rules. The massive takeaway here is that primary sources possess binding legal authority. They simply have to form the bedrock foundation of any argument you make. Period. On the flip side, we have secondary sources. Think of these as your expert analysts explaining the evidence to you. This includes scholarly commentary, law commission reports, and digital legal blogs. Now, while these are incredibly valuable for giving you context, explaining legislative intent, and helping you build out a framework, they critically lack that binding authority. A judge is not forced to rule based on some brilliant legal blog post you dug up at 2 a.m., but they are absolutely bound by a primary Supreme Court precedent. Which brings us to Section 4, decoding a bare act. Let's get into some step-by-step guidance. Reading a bare act, which is the raw, unedited text of a statute, requires a highly tactical approach. You do not just casually read it like a novel. First, you have to grasp the structure. Read the preamble to figure out the legislative intent. Why does this law even exist? Second, rigidly review the definitions section, because words in a statute have very, very specific legal meanings. And finally, analyze it section by section, applying a strict, literal interpretation. Read it exactly as written. Don't speculate on what you think the law should say. It is absolutely fascinating how single, everyday words act as massive legal clues. Changing just one word in a statute from shall to may flips the entire script. Shall means it's a mandatory obligation. It must be done. May creates a discretionary power, meaning it's optional. Should is just a recommendation. And a word like notwithstanding, that signals an overriding provision that trumps everything else. Misinterpreting just one of these tiny little words can literally ruin your case or cost a client millions.
All right, let's bring it all together in our final section, Section 5, the methodology.
Here is the exact chronological blueprint used by top professionals. A meticulous researcher always starts with issue identification, strictly defining the specific legal question. Once you've locked that down, you move into preliminary research. Hit those secondary sources to get the lay of the land. Armed with that context, you dive deep into your databases for primary source research to find those binding statutes. And finally, you wrap it up with analysis and synthesis, actively applying those strict legal principles directly to your client's unique, messy facts.
Now, obviously, the landscape is evolving. Today, modern practitioners are even using AI tools like ChatGPT to find starting points or handle preliminary questions. This is huge in corporate settings, where the goal isn't some abstract theoretical exploration, it's actionable business impact. But here is the golden rule. AI outputs must always be independently verified against authoritative primary sources. Walking into a meeting with a hallucinated case citation is a one-way ticket to professional disaster.
But you know what? Perhaps the most pragmatic reality of this entire job is simply knowing when to stop. The research rabbit hole is real. You know it's time to close the case when you hit a saturation point, when you're just seeing the exact same authorities over and over. You also need to ensure your validation is complete, meaning your cases are still good law and haven't been overruled. And let's be real, tight timelines and client budgets will eventually force you to just make a call and take action. Because ultimately, legal research is inherently open-ended. There's always going to be another book, another case, another article out there. But your true objective isn't to read the entire library. Your goal is reaching sufficient confidence in your legal conclusions so you can articulate your position effectively and defend it robustly, all while dealing with the practical limitations of the real world. And that brings our investigation to a close. As you step out of the library and back into the field, I want to leave you with this final thought. When you get handed your next complex, messy client assignment, will you just be aimlessly searching for information? Or are you ready to wield this methodical toolkit to uncover the truth and build absolutely unshakable legal arguments? Thanks so much for joining me for this explainer, and happy sleuthing.